So I call this meeting to order. So welcome to meeting number 79 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference of Friday, November 25th, 2022, the committee continues consideration of Bill C-20, an act establishing the Public Complaints and Review Commission and amending certain acts and statutory instruments. Today, the committee resumes clause-by-clause consideration. Today's meeting is taking place in a hybrid format. Pursuant to the standing orders, members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefit of officials and members. Please wait until I recognize you by name before speaking. That's a little flexible, you know. As long as we're being friends, we can loosen that up a little bit. But although this room is equipped with a powerful audio system, feedback events can occur. These can be extremely harmful to interpreters and cause serious injuries. The most common cause of sound feedback is an earpiece worn too close to a microphone. In order to prevent incidents and safeguard the hearing health of the interpreters, I invite participants to ensure that they speak into the microphone into which their headset is plugged, and to avoid manipulating the earbuds by placing them on a table away from the microphone when they're not in use. Finally, I remind you that all comments should be addressed to the chair. So I will now welcome once again the officials who are with us. They are available for questions regarding the bill, but will not deliver opening statements. With the Canada Border Services Agency, Cathy Malte, Director, Recourse Directorate. Welcome. Civilian Review and Complaints Commissioner for the Royal Canadian Mounted Police, Joanne Gibb. And Leslie McCoy, General Counsel. Joanne Gibb, Senior Director, Strategic Operations and Policy Director. I've shortened things up a little bit. From the Department of Public Safety and Emergency Preparedness, Randall Coops, Director General, International Border Policy. Martin Lukes, Manager, Border Policy Division. Deidre Pollard-Bussey, Director, Policing Policy. And with the Royal Canadian Mounted Police, Kathleen Clarkin, Director, National Recruiting Program, and Alfredo Bangloy, Assistant Commissioner and Professional Responsibility Officer. Thank you for joining us today. We are at Clause 35, and we'll take things up from there. So from Clause 35, we have block number 6. Allez-y, s'il vous plaît.
The floor is yours. Thank you, Chair. So this is quite a simple amendment. It's simply to ensure that the text follows, along with amendments that we did carry a little earlier here. This is adding the possibility for third parties to make a complaint. Once again, as in the prior amendment, this is about non-governmental organizations. So should we wish to amend this to include this section proposed here at BQ8, I will be certainly open to the change. But of course, it's simply a matter of ensuring that the text follows.
Merci, Madame O'Connell.
Do you support this amendment, but with the same changes in earlier clauses to change, and I would move the sub-amendment, to change non-governmental organizations to third party?
Okay, the discussion carries on the amendment, or sub-amendment. Any discussion on Block 6 as sub-amended? Mr. Julian, go ahead.
Thank you very much, Mr. Chair. I just wanted to ask our witnesses, who we deeply appreciate are here, their sense of the difference between third party as opposed to non-governmental organization. I know that we had a bit of this discussion at the last meeting. I think it would be important for a refresher on the distinction between the two. Who is included in third party, how non-governmental organization would be restrictive.
Thank you, Mr. Chair. I think as with the previous amendments, we see no problem with the intent of the amendment. It is perhaps preferable for the committee to consider third party instead of non-governmental, since it is slightly broader in its application. Many third parties would not fall under the rubric of a non-governmental organization. Some could, in fact, even be governmental in nature or individual in nature.
Thank you, Mr. Chair. I support the sub-amendment, and I'll be supporting the amendment as well.
Thank you, Mr. Yurlin. We go now to Mr. Motz. Go ahead, please.
Thank you very much. To the witnesses, can you clarify for me from last week, did we need language in here that added, excuse me, added the fact that we needed to have a third party can come, but we need to have the complainant actually give that authorization? Do you remember we had that conversation? I don't remember how we finished it off.
No. For privacy reasons we may, but it depends on the nature of the third party, I would suggest. So I don't, as it's written, we don't need it, right, Leslie?
And that's concerning to me. So as written, they don't need it. So you could have somebody who was explained last week that saw an episode of, Canadian Border on TV, or they heard about some friend who had an issue with the RCMP, and before you know it, even though they don't even know, I have never spoken to the actual victim or the complainant of a matter, they can then go ahead and make a complaint on their behalf. That's what I'm getting at.
The commission still has the discretion to refuse. So the third
Right.
party can make the complaint.
Right,
But we
and
still
it-
have the discretion to refuse.
And do the agencies have, before it gets to the commission, do each agency have the right of refusal on a complaint that doesn't come in with authorization from a complainant or from a victim? So CBSA is yes?
Today, I'm yes. In the legislation, I'd have to turn to my public safety colleagues. We've made a few amendments, so I'm not sure if we still have that right or not, because today we do require the third-party authorization.
Right.
The commission remains sort of the point of intake. Even if it's filed at a detachment or if it's from CBSA, it would still come to us to deal with the complaint. So we could refuse to deal with the complaint if there's no connection to that third party. And then the agencies have the discretion to refuse to investigate.
Okay, and that's in legislation. That isn't in legislation though anymore, is it?
Yes, it is.
On specific to this, yes, you have right to refusal, but wouldn't you save yourselves a lot of steps given the fact that we have a significant amount of underfunding for the expansion of the commission? If you had it right in legislation, without authorization from a person who's been aggrieved, or a third party based on this amendment, a third party, the sub-amendment, a third party can actually make this sort of complaint with authorization from an aggrieved individual. Would that not save and clarify, a lot better? Like I save you guys a lot of, no, yes we can, how come you can't, no we're not, how come you're not, and you have that battle back and forth, where right in legislation, if it says, you have to have authorization from the person who's alleged to have been aggrieved in order to pursue this particular matter on behalf of.
In practice, the commission does verify whether there is consent, and in most cases there is, or perhaps in every case thus far. There are some situations where it wouldn't necessarily be appropriate to ensure that there is consent, but as my colleague Ms. Gibb indicated, there are provisions currently in the bill, but also in currently in the Act, but also in Bill C-20 that provides discretion to the Commission to refuse to deal with the complaint for various different reasons. As well, the RCMP and the CBSA have similar provisions as well to refuse to investigate or to cease an investigation if there isn't a sufficient nexus with the individual directly affected.
No, I appreciate all of that, but we're at a stage now where we can strengthen the bill. That's the purpose of clause by clause. And would it not, I'm asking you as witnesses, would it not be better, would the Act not be stronger to have some legislative language in there that suggests that in order for a third party to make a complaint, there has to be the nexus, as you call it, in both agencies. There has to be some sort of connection between the two for a third party to actually pursue a complaint. Now, you said in some circumstances. I'd be interested to know what circumstances those might be.
Hi. Well, I'm just trying to think, trying to recall certain situations. Perhaps in the case of where the individual who was affected by the conduct is deceased, or there's situations where the individual cannot be located. Those are two situations that come to me off the top of my head. But there are situations where it's more appropriate for the Commission or the RCMP or the CBSA to exercise their discretion as to whether or not the matter should be investigated.
Fair enough. I'm going to go to Mr. Coops for a second. We support the intent behind this legislation, and we've talked before and in this committee about how to make it stronger to ensure that a complainant is properly looked after. But we also we have both sides of the coin we have to look at. We have to look at the organizations who are tasked with investigating these, and we have to look at the victim or the alleged aggrieved individual or individuals who might have a complaint against CBSA or the RCMP or the Commission for that matter. To clarify language in this act at this stage to ensure that there's no ambiguity as to when and where a third party and why and how a third party can actually launch an investigation, pursue it. Now, I know the language is in there currently in some of your cases. I know that the act, currently you have the ability to not investigate. But having done these, to go through and explain it and the energy it takes to explain it when you say the act is very, very clear. Unless you have, you don't get, right? So it's only a matter of adding, with authorization from the aggrieved individual or something along those lines. I'm looking just for your opinion, Mr. Coops, on that. Given what each of the acts, what each organization acts they work under for complaints, and then now expanding this to include the RCMP or the CBSA, would it not improve our legislation to have that in there?
I would just caution Mr. Motts that the witnesses are not able to speak to policy decisions. I think they have to limit their responses to their roles as officials of the department.
Yeah, I appreciate that, but we're also talking about ensuring that we get some. Anyway, they understand what I'm asking, and if they can answer, great, and if they can't, I guess I got my answer.
I'll try my best to answer.
Thank
I
you.
think if we look at the amendment to Clause 35, which is to expand the grounds of who can, in essence, request the Commission's assistance, which is consistent with a change made earlier in the bill, that be expanded to third parties. That does not change the responsibility or the authorities of the Commission to determine whether it wishes to investigate that complaint or whether that complaint meets the statutory threshold that exists elsewhere in the bill. So expanding the class of persons who can bring the complaint doesn't change the process by which the Commission will itself, or in the instance of the RCMP or CBSA, make a determination if they believe that that person has adequate standing, which could extend to consent or other grounds, that they would, using their delegated authority in the statute, decide whether that third party has sufficient grounds to bring the complaint.
Thank you.
Thank you, Mr. Chair. The answer given really explains it, but just to put the point home once again, I think that allowing this puts in the legislation that there is the opportunity for this through the Act. However, there are regulations and internal processes that still exist that allow for the Commission to determine if it meets an internal threshold. But I think we need to keep it open, not close off the ability, because you sometimes don't know what situations might arise. And so we want to provide, and I appreciate the Block's amendment on this, you want to provide the opportunity in the event there was, especially in a situation where it could be of great public interest, the opportunity for an investigation or a look at the situation. So to limit the scope in the act then limits the flexibility with the commission. And so I think this provides that opening, but there are still checks and balances in place to ensure they're not frivolous, they're not based on an episode of border security or whatever else is being referenced, but that there is that opportunity and that we're not limiting the scope too severely. So I think it's a good balance of keeping it open but allowing for the flexibility to ensure that they're not frivolous complaints being filed.
Okay. Seeing no further discussion, the vote is on Ms. O'Connell's sub-amendment. All in favor?
On division?
On division? Okay. Clause, sorry, one more. We have to go to the actual amendment.
Very true.
Thank you, Mr. Julian. Indeed. Is there any further discussion on the motion as amended? Seeing none, all in favor?
On division?
On division? Okay. Okay. Shall clause 35 carry as amended? All in favor? Opposed? Mr. Julian, go ahead.
Yeah, point of order, Mr. Chair. We have NDP 23 on clause, which creates a new clause 35.1.
Clause 35.1, so that's, we'll get to that after we finish clause 35.
Sure.
Okay. All right, so I believe the discussion, or I believe that vote was on division. Is that correct? Yes? Shall clause 35 carry? All in favor? Opposed? Carried. That brings us to new clause 35.1 and NDP 23. Mr. Julian, if you please.
Thank you very much, Mr. Chair. This is a recommendation that comes from Breaking Barriers to ensure, for further clarity, that the use of non-disclosure agreements are prohibited within this Act by the Commission, the RCMP, CBSA, when dealing with complaints of misconduct both internally and externally. So what it would do is create a new clause 35.1 that complaints made under this Act shall not be subject to a non-disclosure agreement. And Mr. Chair, just very briefly, some of the members around the table have been part of the discussions at Canadian Heritage, and we saw how the absence of safety in sports was covered up over many years by the use of non-disclosure agreements in a rampant and inappropriate way. And so the recommendation from Breaking Barriers makes sense, that non-disclosure agreements shouldn't serve to hide activity that is taking on, that is happening, and so for complaints of misconduct, there should not be the ability to obscure that, not be transparent through the use of NDAs.
Thank you, Mr. Julian. We go now to Mr. Shipley.
Thank you, Chair. Just quickly, is this to our officials? Is this currently an issue, and do NDAs, are they currently used in the civilian complaint process?
NDAs aren't generally used in the review process. They are a tool that is employed sometimes in the context of civil litigation and in settlements arising from civil litigation. There's no provision in the Act whatsoever that an NDA would preclude the Commission from having access to necessary information. We would view it as an unnecessary provision. My colleague from the Commission may have more details about their current situation.
Yes, there's no provision in the Act either allowing or prohibiting non-disclosure agreements, but they aren't typically used. Certainly the Commission has never imposed a non-disclosure agreement. I suppose it could conceivably arise in the informal resolution process, either at the RCMP or the CBSA, but I'm not aware of it having been used.
Mr. Lloyd.
Yeah, so I was a bit confused about this because I was wondering if we're subjecting the Civilian Complaints Review Commission to say they can't utilize NDAs, but it seems clearer now that this is about, previously agreed upon NDAs from, civil litigation that happened that led into a complaint. And what this amendment is trying to say is that, NDAs can't supersede the complaint process. But a concern I have is, does the government really have the power to break an NDA? And if somebody is going to, break an NDA in order to make a complaint to the commission, there's nothing that the government can do to protect that person from a reopening of the civil litigation. So it seems to me there could be a concern that we might be confusing people and making them think that you can tell anything to the Complaints Commission without consequence. Of course, we want them to be able to tell the Complaints Commission everything that they feel is necessary, but I wouldn't want people to be confused and thinking that, they're protected under the NDA. I'm not that familiar with NDAs myself, but I'm just concerned that we could be creating confusion. Anyways, that's what I have to say about that. But any thoughts from the witnesses, perhaps?
Yes, I think you're correct. It could create confusion because it would only apply to NDAs under the PCRC Act, and in fact, as you indicate, the NDAs agreed to in civil litigation would not be prohibited by this provision, and in fact, then individuals might be restricted in what they can disclose based on previous civil litigation NDAs. That is correct.
Well, I appreciate the civil side. My question relates more to complaints that might arise that have a national security flair to them. And there may be some non-traditional, non-civil non-disclosure agreements based on some national security issues. Would this addition then cause some concern if there was a complaint made about an investigation done by the RCMP, for example, in a matter that is of a national security concern? Maybe they overstepped an authority, or that's the allegation they've overstepped an authority, but at some point throughout that, because of the national security concerns, there was a non-disclosure agreement arrived at some point in time with a witness or whoever. Would that create a problem with that investigation? I mean, I see non-disclosure agreements as a blanket having huge concern for investigations, right? Because you can only make a decision based on the information you have, and if information is being withheld because of a non-disclosure agreement, civil or otherwise, then you've got you have a less than fulsome suite of evidence to use, right? So I'm just kind of curious to know whether a national security concern would play into this at all, and should we be alarmed by having this particular amendment considered under the Act?
We'd offer that is a foreseeable concern, but that the national security provisions in the Act governing both the access of the Commission to national security information and then any further public release of national security information, the provisions that are already in the Act would prevail.
So, again, an overarching non-disclosure agreement, does this clause cause concern for the strength of this legislation?
I think the best view we can offer is that it appears unnecessary to us. The Commission or the agencies may have more direct experience with that.
And I'll certainly defer to the CBSA and RCMP to answer that if there's an issue. But I think that statement is enough for me to recognize that it's probably not necessary, and I won't be supporting it. Thank you.
Thank you, Mr. Motz. We'll go to Ms. O'Connell.
Chair, again, the witnesses, I think, clarified, but I want to hit home the point that matters of national security, those who have the information would be subject under other legislation in terms of protecting national security. So whether that's members of the RCMP, CBSA, or a third party who had access to that information, would they not still be subject to anyone who gains access to national security documents? And Glenn and I both have had this, where before you sign, you're indoctrinated. It's such a weird title, but you have to sign, and you are subject to that for life. So a non-disclosure agreement would actually be the lesser of the legal kind of ramifications that anyone that has access to national security information is already subject to much stricter legislation in terms of revealing that. Is that correct?
Yes, the Security of Information Act would apply.
Thank you. So I think on this I don't have the national security concerns that were outlined because, like I said, there's stronger, higher legislation that covers that with stricter penalties. But in terms of a non-disclosure agreements and kind of banning them, I'm of two minds. I do understand where there could be a legitimate reason why you might want one. But I think more often than not, they're used to silence victims. And I think the harm outweighs the good. And they're used as a bargaining opportunity often. And I'm not saying this as, any wrongdoing that's done here, but I'm looking at them. Mr. Julian pointed out in the instances of Hockey Canada, et cetera. I think, though, they are meant to settle things quickly, settle things quietly, and oftentimes, as a result, might resolve that individual person's grievance or complaint, but allows for systemic issues to continue. And so, on the whole, as I said, I could see where there could be opportunities or times where they may be completely legitimate and fine, but I think the harm outweighs, or the potential harm outweighs the rare instances, I think, where they'd be used as a way that are fine. But I think they often are used to hide systemic issues, or the public, even the agencies themselves, may not fully understand the extent of a problem because of the overuse of non-disclosure agreements. So I will support this amendment for that reason. I can certainly understand both arguments, but ultimately I think the potential harm outweighs the good of having them.
Thank you. Mr. Julian.
Yes, I couldn't agree with Ms. O'Connell more. What she pointed out is the problems that we've had with the use of non-disclosure agreements have been to essentially stop victims from speaking out, which has meant in our sporting systems over years, abuses in Hockey Canada, abuses in other national sports organizations, those systemic abuses have not been exposed because of the use of non-disclosure agreements. It's basically a payment in return for silence. If we are putting into place a transparent complaint process, that's why it's important that non-disclosure agreements not interfere with that transparency, so that when there are systemic problems, we can actually identify them. So I think for those reasons, the potential harm of NDAs that we've seen in real time in other sectors, literally covering up for, in some cases, decades, systemic problems, is something that needs to be identified in this legislation so that we're moving forward with a transparent and effective complaints process.
Thank you. Mr. Lloyd, you good? Any further discussion? All in favor of NDP 23? I'm not seeing on the screen here.
I think their hands were up. It's just a little.
Okay. So opposed? Carried. We move now to Clause 36. Shall Clause 36 carry? All in favor? Opposed? On division, okay. Clause 37. This brings us to CPC 8. Mr. Shipley or someone on your bench, go ahead.
We will not be moving CPC 8. We will withdraw that.
Withdraw, okay. So shall Clause 37 carry? All in favor? Opposed? Carried. Clause 38 brings us to CPC 9. Mr. Shipley.
We will also not be moving CPC 9. We will withdraw that.
Okay. That brings us to NDP 24. Mr. Julian.
Thank you very much, Mr. Chair. The speed with which we're moving through these amendments, if you'll give me just a moment to gather my thoughts. I appreciate my Conservative colleagues withdrawing, and I commit to withdrawing more amendments a little bit further on. As I mentioned at our last meeting, issues that we've already discussed, debated, and voted on, I don't intend to re-adjudicate. So that will mean that the number of amendments that we have to consider from the NDP will decrease significantly, and I appreciate the Conservatives also facilitating that work. In this case, the NDP 24 proposes that Clause 38 would be amended by deleting lines 11 and 12 that currently state is not the individual at whom the conduct was directed. And what this is a commissioner directing the RCMP or president directing the agency not to commence an investigation of a complaint if, in his or her opinion, the complaint is from an individual is not the individual of whom the conduct was directed. Now, Breaking Barriers believe that this is something that could lead to a victim not stepping forward if there are any fear of reprisals. It would mean that essentially there would be an opportunity not to do the investigation. We seek, and Breaking Barriers recommended this, seek the removal of that clause so that the investigation can still be undertaken. There are a number of other groups as well, Mr. Chair. You'll remember from our witnesses that asked for the same thing. So removing that one clause to ensure that is not a pretext not to commence an investigation of a complaint if the victim themselves feels uncomfortable stepping forward.
Thank you, Mr. Julian. Mr. Motz, go ahead.
So, to the witnesses, with the amendments that have been made with respect to third parties, would that have any impact then on this amendment, or NDP 24? Because I think it's kind of problematic to remove that sentence from there, and yet I see Mr. Julian's point. But would with the amendment made of a third party being able to make a complaint, Does this then, does it render NDP 24 kind of moot? And maybe that's a question also for the legislative clerk. I don't know. Them first, and then you guys weigh in. It's safer that way, isn't it? Whoever.
I don't think we can offer you a view on whether it is rendered moot or would render moot the other amendment. We would just note that that is simply one of the conditions that is set out for the commissioner or the president to take into consideration under their grounds of the right to refuse to investigate. The others that follow provide other things they may consider, including whether that person has consent or is acting in a role on behalf of that other person. A complainant who's not satisfied with the decision of the chair of the commissioner or the president in that case, of course, can bring that complaint to the commission to be reviewed. The net effect, however, of removing sub 1 would be that it may increase quite considerably the number of complaints that are brought to the commission because it would open much more broadly the class of persons who would feel that they are entitled to bring complaint about things that do not directly affect them.
Okay, and just to follow up to that then, I guess if I'm reading this right, the intent of removing this for Mr. Julian's intent to remove this would be that he doesn't want to narrow the scope of an individual who is not the complainant to make a complaint, which I think we have as a third party already. That's in there. So I just see this as being a problematic amendment, and I certainly can't support it. Thank you.
Thank you, Mr. Chair. Just very quickly, I also can't support it because of my comments earlier that if we want to allow for others to make investigations, we still have to have some flexibility in terms of determining frivolous or creating some standards within the agency. And I think, though, keeping that in mind, that if there are internal practices of how complaints are handled or refused, that ultimately there will be reviews and looks at how those internal standards are created. And if they are not being adjudicated effectively, I think then there could be more conversation. But in terms of legislation itself, my comments earlier said that we do still need some flexibility for the Commission to weed out frivolous complaints or complaints that would not meet the standard in terms of a more formal investigation. So I can't support this amendment based on those reasons.
Thank you. Mr. Julian, go ahead.
Thank you very much, Mr. Chair. That the right to refuse investigation because the complaint is trivial, frivolous, vexatious, or made in bad faith already exists in the legislation. That's not changed. What the commissioner can do and the president can do is to direct not to commence an investigation if any complaint is trivial, frivolous, vexatious, or made in bad faith. That doesn't change. The second clause, clause B, is the complaint is from an individual who. And what is included in that is a number of different criteria, including did not see or hear the conduct or its effect as a result of not being physically present at the time when and the place where the conduct or its effects occurred. So there are many provisions that exist for the exact reasons that Ms. O'Connell just has set out. I would suggest the reason why Breaking Barriers made this strong recommendation is because what that does, given all of the reasons why an investigation could be directed not to continue, the fact that an individual, for very valid reasons, concerns about what the exposure might mean, might not make the complaint themselves, means that removing this clause would still give the commissioner and the president a wide scope to not continue an investigation, But one thing they couldn't point to is an individual who, for very valid reasons, has chosen not to step forward, even though there were witnesses to the conduct who are willing to step forward on their behalf.
Thank you. Any further discussion? All right. All in favor of NDP 24? Opposed? Defeated. That brings us to Block 7. Allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Chair. This is indeed a matter of concurrence, adding a third party that can initiate a process, file a complaint. I would be favorable to a sub-amendment to change non-governmental organization to third party in what I'm proposing here.
Just move it with the third party. There you go. Okay. Any discussion? Seeing none, all in favor of Block 7? All opposed? On division? Okay. And note that that was moved with third party. Right? Thank you. We go now to Block 8. Madame Michaud, allez-y, s'il vous plaît.
Go ahead, Ms. Michaud. Thank you, Chair. BQ8 is also an amendment to ensure concurrence rather than discrepancy. And this time, it's about copies of communications that could be shared with a legal representative. And we adopted an amendment a little earlier, allowing legal representatives to receive notice in writing or copies of documents should the person they're representing being outside the country or be otherwise difficult to reach. So again, this is simply to ensure concurrence, to have no discrepancies, which respects a request made by a legal association.
Seeing none, all in favor of BQ8? Carried. Shall Clause 38, as amended, carry? All in favor?
On division?
On division? Okay. Clause 39, that brings us to CPC 10. Mr. Shipley, if you please.
I will not be moving CPC 10 and will withdraw that amendment.
Withdrawn. Very well. Shall Clause 39 carry? All in favor? Opposed? Carried. That brings us to Clause 40 and NDP 25. Mr. Julian.
Thank you very much, Mr. Chair. What this seeks to do, and this as well was a recommendation from Breaking Barriers, would be to include in Clause 40, replacing line 33 on page 27, by adding the words, "and the reasons for the withdrawal." This is something Breaking Barriers recommended to this committee. In this way, it is better to understand, for example, the reasons for the withdrawal of the complaint. Is it because the process has taken too long? Are there other concerns that have been raised? So this would include reasons for the withdrawal for the information that is then sent as a written notice to the Commission or the Commissioner. And as I mentioned, a recommendation from Breaking Barriers.
Thank you. We go to Mr. Shipley.
Thank you, Chair. A couple quick questions to our officials. Is there any process like this now where you have to give a reason as to why you're withdrawing a complaint?
No, reasons don't have to be provided.
Do you feel that there would be any benefit to having this in there, or do you not think we're being a little bit overly onerous on complainants to ask for their reason?
I think it would be beneficial. During COVID, when we were all working from home and online, people had to submit their withdrawals via email. And a lot of times it would be included in there, the reasons they were withdrawing. Normally the Commission wouldn't see that. So understanding why they're withdrawing, understanding that they're not being pressured to withdraw a complaint would be helpful.
Well, that makes a little bit of sense then. Is there any way then? Thank you. You're welcome. We agree on a lot of things. Is there any way it could be done where it was more of a box submission, like a check mark, instead of them having to write, their own paragraph or essay or whatever? Is there an easier way, or how would you go about actually doing this?
If the individual made the complaint or requested a withdrawal from the Commission, we could ask them the reasons why. Conversely, if it's done on a detachment, it's only the RCMP here, they could do the same. I mean, a lot of times the individual will say, time has passed, or I'm no longer interested, I've had a couple days to think about it, I want to withdraw. So,
And would they have an opportunity, I don't know how we can make this mandatory, would there be an opportunity to say, do not want to disclose their reason?
I suppose we should make that an option, yeah.
Yeah, I would think so. Okay. Thank you for that. Thank you for the clarification.
Thank you. We're going now to Mr. Motts, but I should have mentioned earlier that if NDP 25 is adopted, CPC 11 cannot be moved due to a line conflict. Mr. Motts.
Okay. I think there's some value in this, as we heard. Can we change it rather than and, or do an and or? Like, so that they can just do a withdrawal, but we're requiring them that they have to give a reason for the withdrawal, if they wish. It should be something. I don't know if Mr. Julian is interested in making, to even entertain that. But it's, if you make it arbitrary, then they may not answer it. Then what? If it's a requirement, then what? Right. So if they wish, would be something we can add potentially.
I would suggest it's actually not up to Mr. Julian at this point. It's
I know,
it's been moved, and if you wish to make an amendment, sub-amendment, go ahead.
This is whether there's any value in having words like that added to it.
We could also just put an option, prefer not to say.
On a checkbox, if you're using that.
Yes.
Okay, fair enough. Thank you.
Ms. O'Connell.
Thank you. I think my line of questioning is similar. It's just that there would be no recourse should someone wish not to say. That would be my only concern, that if they just choose to withdraw, and that there wouldn't be some sort of follow-up or issues in terms of if they just prefer to leave it. No, but but seriously, I just don't want to, if it's in the act, I don't want to maybe an overzealous, situation where, again, a complainant coming forward could be intimidated or any kind of negative recourse, just in terms of trying to scare them. So I just want to make sure that I see no issue with supporting, understanding that information. I just want to make sure that there would be no form of recourse, like they can't then ever complain in the future, or they can't ever raise other issues. So I just want to be crystal clear on what this does, but I'm not overly concerned about it.
Okay. Any further discussion? So on NDP 25, all in favor? Mr. Doolin?
Mr. Chair, if all parties are supporting, that's wonderful. Another way of achieving that would be to use the word any instead of the. But I think we've gotten clarity from the witnesses, as they always do in such an excellent way. So I think it's clear, if there were any concerns about it being sort of a mandatory, obligatory thing, that's not going to happen. But if there were concerns about it, I would be open to that one word change. But if all parties are supporting it, we can just move ahead.
Okay, all in favor of the motion, NDP 25? Opposed? Carried. So CPC 11 cannot be moved due to a line conflict. So shall clause 40 carry? On division? Okay. Shall clause 41 carry? On division? Shall clause, clause 42, we go to BQ 9. Allez-y, s'il vous plaît.
Allez-y.
Go ahead. Thank you, Chair. Once again, a matter of ensuring concurrence. This is about, again, the non-governmental organizations and their ability to make complaints or withdraw complaints. And so I just suggest that we substitute third party for non-governmental organization in what I propose here.
With the change for third party instead of non-government organization. Any discussion? Seeing none, all in favor? On division? Carried, on division. Shall clause 42 as amended carry? All in favor? Opposed? Carried. This brings us to new clause 42.1, CPC 12. Go ahead, Mr. Shipley.
Thank you, Chair. And we will be moving this one. So this, I'd like to move CPC 12, and I'll just give a brief explanation on this. This amendment would provide remuneration for back pay for officers who were suspended during investigation if the complaint was withdrawn or unfounded. And just a little bit of rationale for that is this amendment addresses an issue that was raised by the CBSA union. Currently under the CBSA's complaint regime, if a serious allegation is made against an officer, that officer's security clearance is revoked. Therefore, they are not suspended and not fired, but they cannot go to work, and they do not receive any pay. Ultimately, if a complaint is deemed to be unfounded, that officer must go through a lengthy grievance process to receive any back pay. This issue is obviously very devastating for our hardworking CBSA officers, and we hope all committee members can support this very reasonable amendment.
Thank you. Ms. O'Connell.
Thank you, Mr. Chair. I'd like to ask officials on this one. I never understood the PCRC as a disciplinary process to be able to remove or implement some of, these disciplinary actions. So I guess my concern would be, or I'd actually rather hear from officials in terms of if there is a disciplinary process where, let's say, a member is suspended in the, while it's being investigated, but that would be, that wouldn't be as a result of the PCRC work, or perhaps you could elaborate into how the PCRC, the intersection between that process and disciplinary hearings or disciplinary judgments while an investigation is going on, something along those lines. Like, would the PCRC actually put in place those measures, like, let's say, in the example of suspension and removing pay? Because if not, then it wouldn't be as a result of the PCRC investigation, and then that would be probably a union issue with the body that suspended the individual. Am I understanding that correctly? Or perhaps someone could explain it more clearly.
In our view, I think that understanding is correct. The intent, the design intent behind the bill is that the PCRC not be brought into the realm of discipline. In the case of the RCMP, there is already a separate external body to deal with that. The Act as drafted explicitly excludes the PCRC or the statute from dealing with any measure related to discipline. That is better dealt with in the existing domain of labor law and the disciplinary process. There was nothing in the government's design intent in the legislation to bring anything into the statute in relation to suspension, return to duties, and compensation, which would otherwise be outside the realm of the PCRC and subject to the jurisdiction already of the Federal Public Sector Labor Standards Board. I may have the term wrong.
Thank you. So, Mr. Chair, with that being said, I can't support this amendment because if an individual was suspended without pay or any other disciplinary action, that they should take that up within the processes of who made that disciplinary action. And the PCRC's process, even if a complaint is ultimately withdrawn or whatnot, there would have been an internal process, whether the RCMP or CBSA, to take that disciplinary action with or without the PCRC. So I don't think the two should be correlated, and I think that if there is an unfair disciplinary action, there is recourse that exists between the union and or the again, whoever made that disciplinary action, which is not the PCRC. So I can't support this amendment.
Thank you. We go to Mr. Julian, followed by Mr. Motz. Mr. Julian.
I do have concerns as well. And so I'd like to ask our witnesses, so if the PCRC is disagreeing with the RCMP or the agency's decision on the complaint, what, in the opinion of our witnesses, would be the result? This seems to it seems to be a missing part of the amendment. What do you see the ramifications? I'll ask our witnesses of this in a case where the PCRC is in profound disagreement with the decision of the agency or the RCMP.
The founded or unfounded would come at the investigation at first instance. So after CBSA or RCMP investigates, the PCRC wouldn't really even have a role until the complainant requested a review, if the complainant requested a review.
Let's assume that the complainant does.
So if there is a review requested and the commission is in disagreement, we would do an interim. We would write an interim report that has findings and recommendations to the minister, or pardon me, to the commissioner or to the agency, a copy to the minister, and then the commissioner or the president would have the opportunity to respond.
Okay, thank you. I certainly understand the intent of the amendment. I'm not sure that the wording here actually accomplishes what the intent was. So in its current form, I can't support this amendment. Thank you.
Thank you. Mr. Motz, followed by Mr. Shipley. Mr. Motz.
Thank you, Chair. Well, I agree with Ms. O'Connell's explanation that generally matters of discipline would fall under both agencies, the RCMP and CBSA. And during an investigation, it's their own protocols that set out whether or not an individual who is the subject of a complaint And is the complaint serious enough that either they need to be suspended with pay, suspended without pay, pending the outcome of investigation? Now, I understand the RCMP's process a little bit better. Now, this is the CBSA union that had some concerns. So can CBSA explain to me what's going on inside the organization that these members feel that they want this language in the act? Do they not have recourse now? Is that a clumsy process? I mean, if you have a 6 or 8 months or a year-long investigation, and then they're without pay for that length of time, and they get found to be not guilty, or the complaint is withdrawn, or frivolous and vexatious, whatever the outcome is, if they're not responsible, that's what's found, there should be an automatic reinstatement of their pay, back pay included. And so I'm curious to know whether or not they have to go through a very litigious process to get what they're rightly due back. And I don't know the answer to it. Obviously, there has to be something for them to have this concern.
So I can't speak on behalf of the union because they're not here today, but my understanding is that they're mixing different les processus d'investigation. So the public complaints investigation is a separate process. Like I mentioned last time, we have service standards of 40 days that we meet 90% of the time. But the professional standards investigations or labor relations code of conduct investigations, that's a whole separate process within CBSA that is not part of the public complaints process. So while a public complaint may have brought to light the conduct of an employee, the complaints process will follow through within the 40 days to say yes, support it or not. And then the professional standards investigation process or labor relations process, and I can't speak on their behalf because they're not here today, that would be their separate piece with the collective agreements, with the grievance rights, with all of everything else that is part of that statute, which is outside of this. So one triggers the other, if you will, because one may bring up the conduct of someone, but it's not an actual public complaints investigation that would make an employee go on leave without pay or anything else. Like, we have nothing to do with the employee, then it moves on to the other processes that are legislated.
Fair. So, Mr. Julian, and I don't want to put you on the spot, but I'm going to anyway. You had suggested, you understand the intent of this. If the language is clumsy, and I don't have any suggestions for increase or change in language, do you have anything that comes to mind that would change this so that it's palatable and still accomplishes what we were trying to accomplish?
We have Mr. Shipley before Mr. Julian, but I'll let Mr. Julian respond directly.
I don't have any brainwaves, Mr. Chairman.
Okay, thank you. Mr. Shipley.
Thank you, Chair. Mine will be fairly quick, too, because Mr. Mott's asked a fairly similar question. I just want to make it, or I don't want to make it clear, I want to get it clarified to me. Ms. McConnell mentioned that this is during discipline issues. What we're looking for here is this is not a discipline issue, why they'd be losing pay and being off work. This is that they get their security clearance revoked and can't work. So they haven't been disciplined. They're getting it revoked during the investigation. So there's been no discipline handed out. It's not a discipline issue. So that's what we're looking for, on a bit of clarification on that, if we could, please.
Maybe ask specific persons.
Again, we would just observe that suspension and things flowing from it are from the operation of another statute. They are from the operation of whatever labor statute applies and whatever collective agreement applies in that context. This amendment would impose on the commissioner or the president an obligation about the employment status of an employee in the PCRC statute when it was the operation of an entirely different statute that may have created that situation, and that is not part of the operation of PCRC or of the complaint itself. It results from a disciplinary decision that was made by the president or the commissioner. So, bref, I think we conclude that whether that outcome is desirable or not, this may not be the proper statute to achieve it through.
Thank you.
Any further discussion? Seeing none. All in favor of CPC 12? Opposed? Defeated? That takes us to Clause 43. So Clause 43 carry. All in favor? Opposed? I think that's a yes. Okay. Clause 44, we have NDP 26.
Thank you very much, Mr. Chair. This was a recommendation members of the committee will recall from the Canadian Association for Refugee Lawyers regarding a third party, which is a principle I think we've brought forward in the bill as well, allowing in the section on representations, which is Clause 44, to include there's some clarifying language, but essentially to include a person or entity with substantial interest in the subject matter of the complaint, acting in the public interest. For reasons that we've had prior to, in terms of investigations, it's important to have those third parties being able to make representations on specific complaints. And so I certainly hope members of the committee will support this recommendation from the Canadian Association for Refugee Lawyers.
Thank you. So I have to let you move it before I can rule on it. So my advice here is that this amendment seeks to introduce the right to make representation in relation to complaints about the policies and procedures of the agency, which is a new concept that goes beyond the scope of the bill as adopted by the House at second reading. So an amendment to a bill that was referred to the committee after second reading is out of order if it is beyond the scope and principle of the bill. So in the opinion of the chair and for the above stated reason, I rule the amendment inadmissible.
And Mr. Chair, with all the deep respect I have for your abilities, I think it's fair to say throughout this bill, what we've been trying to do is ensure that third parties do have the ability to intervene in complaints. So with the deep respect I have for you as a fellow British Columbian, and you've done an admirable job as chair of this committee, I'll have to beg to disagree on this particular question, and I'll have to challenge your ruling.
No problem. So the question is, shall the decision of the chair be sustained? If you vote yes, you're voting to sustain the decision of the chair. If you vote no, you're voting to overturn that decision. So let's take a recorded division on a recorded vote on this. I'm sorry? Yes is with the chair, no is against the chair. Not against the chair, but against the chair's decision. There you go. Never against the chair. Indeed. All right, so Mr. Clerk, if you please. Mr. Shifke.
Ms. O'Connell? Yes. Mr. MacDonald?
No.
Mr. Gair?
Yes.
Mr. Biddle? Mr. Shifke?
Oui.
Mr. Shipley?
Yes.
Mr. Lloyd?
In favor.
Mr. Mutz?
As much as it pains me to again agree with the chair, this week as last, yes.
Mr. Millaloo? Madame Michaud?
En faveur.
Mr. Julian?
No, contre.
2 against, 8-4.
So the chair's decision is sustained.
Sorry, what was the result? Was it 10 to 2?
8 to 2.
10 to 2. Well,
See,
thank you.
You found some support out there. Okay. Okay, so So PV2 is inadmissible for the same reason. Okay. So this brings us to CPC 13. So if CPC 13 is adopted or defeated, NDP 27 cannot be moved since they are identical. So we go to CPC 13.
Thank you, Chair, and I will be moving CPC 13. This an explanation. This is amendment would allow union representatives to be made on behalf of an RCMP or CBSA employee that is subject to a complaint. I'll keep that short and sweet and see what the rest of the committee feels about that.
Any discussion? Seeing none? Mr. Julian?
Absolutely support CPC 13. As you can see from the package, Mr. Chair, they're worded exactly the same as NDP 27, and the idea that RCMP and CBSA members have the right to union representation, I think, is a fundamental principle within Canada's system of collective negotiations and labor rights. So I completely support CPC 13 and thank the Conservatives for presenting it.
Thank you. Any further discussion? Mr. O'Connell.
Thank you, Mr. Chair. I think the wording is just a little bit, I want to get a little bit more clarification. So could I ask officials if this is the best clause to be included and where in the legislation it spells out the rights of those employees who have filed a complaint or filed a complaint against them? So I'm not necessarily opposed. I'm just not sure if this is the right wording, if this is actually helpful or not. So perhaps I could get some more insight from officials on how they see this clause working in the legislation.
We would have the same concern from our analysis. Clause 44 is not dealing with a broader right of the union to make representations on behalf of the employee. It is a much narrower grounds about making representations with respect to the conduct's impact on the person who was the recipient of the conduct. So it is actually giving the unions the right to make representations about what may or may not have happened to the person who ends up as the complainant. That's a very different thing from the union making representations about the effect of the employee or on behalf of the employee. So from that perspective, we think that may raise some concerns.
Thank you. So again, it's the whose conduct is the subject matter of the complaint. Okay. So could this cause issues in terms of, or could you foresee this causing issues in terms of just the investigation? Because the PCRC's role is to investigate the matter, and issues of disciplinary action or conduct would be outside of that, the PCRC scope, but simply to look at what happened, determine if there are changes that need to be made. And so could this be seen as a situation where it could actually limit the ability for the investigation to take a look at the actual complaint?
I don't think it would limit the ability to do an investigation, but I think, as earlier noted, the desire to have union representation is somewhat different than having the unions be allowed to make representations at what is essentially a victim impact statement. As it is right now, RCMP members, if they want to have the National Police Federation member with them when they're being interviewed, that's permissible.
Okay, so it doesn't limit the ability for the unions or for someone to have their union representative with them throughout any stage of the process, but this would be kind of above and beyond that that wouldn't necessarily be just the represented. Am I understanding that correctly? That this is above and beyond just an individual's representation?
Yes, that's our understanding.
Okay, perfect. Thank you for the clarification.
Thank you. That line of a thought is, do you ever foresee an opportunity or a possibility that in the odd circumstance, the subject of a complaint, not the complainant who's been aggrieved with, the subject of a complaint could find themselves in a spot where they could make representation on behalf of what the complaint has done to them? Because as part of the investigation and at the end of the adjudication process, it may be found to be frivolous and vexatious. And I think is there a possibility then that gives a member of the RCMP or CBSA an opportunity through their different associations representation at this particular clause to not defend but to explain the impact that the investigation has had on them or their family or whatever it might be, just like, as was said, a victim impact statement?
So the proposed amendment as written does not allow the subject of the complaint through their representative to give comment on the impact on themselves. It only allows comment on the impact of the we'll say victim, the person impacted by the either RCMP member or CBSA employee conduct. So, as written, it does not allow representations to be made of the effect on the subject of the complaint.
Yes, it's directed specifically only to a complainant.
Okay, any further discussion? Seeing none, all in favor of CPC 13? Opposed? Carried, I believe. So NDP 27 cannot be moved. That takes us to NDP 28.
Thank you, Mr. Chair. And this was a recommendation from Breaking Barriers and is a fact that was documented through the Merlot-Davidson lawsuit that there are concerns once a complaint arises about the complainant not getting ongoing support. So this would add a new section 2.1 in clause 44 that would allow the commission to continue to maintain contact with the complainant to ensure that there is not any untoward influence. So this is a recommendation that came out of Breaking Barriers to protect the complaint process.
Thank you, Mr. Julian. We'll go to Mr. Shipley.
Thank you, Chair. To the officials, so if this was put in place and passed, who would be able to do these contacts monthly? That seems like it potentially could be a lot. And also, yeah, basically, what would the human resources required and removal from your current resources to maintain and do this monthly contact? Can you give me some enlightenment on that, please?
Our assessment is that it could be a very onerous burden. A conservative assumption would be that it would create about 60,000 touch points a year, over and above 60,000, yes, over and above the Commission's existing workload, in checking in with 5,000 complainants 12 times a year over a duration of an average of 1 year.
So 60,000 contacts over a year. I mean, these contacts must take a while. Do you have any idea how many full-time employees that would take to do a role like that?
Lots. Is that sufficient?
No.
Dozens.
Any ballpark, guys? I don't have a clue.
I would think dozens.
Sorry?
Dozens?
Dozens. Okay, thank you.
It also comes on top of the existing check-ins that are obliged in the Act from CBSA and the RCMP of reporting to the complainant about the progress of their complaint and the status of the investigation.
Mr. Motz, go ahead.
Thank you. First of all, I think it's important to hear that this amendment makes it sound as if the agencies or members inside of these agencies who have the complaints made against them, it's their mission to harass complainants so they change their mind. I find that rather offensive to even suggest it. But however, there is always those one-offs of individuals who might, who might overstep and interfere with an investigation, and we've seen them from all sides do that. But excuse me. So is it, does it make sense that as part of your normal process of checking in with a complainant, whoever that might be, on the status of investigation which is legislated, that you would ask those questions as a matter of practice anyway? Like, is there anything new to report or anything along those lines that would give rise to an opportunity for them to do to report exactly this, if this was actually happening? Is that a reasonable thing to expect from all the agencies when they do check in with the complainants during an investigation?
The RCMP and CBSA have to send a monthly update letter to the complainant. So it's already being sent. I suppose you could insert something like that. I know our complainants now, there are some that are quite well informed, and when they don't receive their monthly update letter, they will file a second complaint, and that is a complaint we will take if they didn't get their monthly update.
Okay. So from the agencies, RCMP and CBSA, if you're sending these out, if you have to send to the commission the update, you're obviously sending them to the complainants as well. Is there an avenue there to if they wish to add more information, or is there anything new happening? Is that something that is a matter of practice now?
For the RCMP, as a matter of practice, we just advise them of the status of the investigation. But certainly if the complainant has any other complaints of any type of harassment or anything like that, we definitely take that seriously, and it would result in the initiation of potentially a statutory investigation or another code of conduct, a disciplinary type investigation.
If they bring it forward on their own. I think the intent of Mr. Julian's motion is to provide an avenue so that they can at least get asked. But so if I'm hearing you right, you don't necessarily ask them if there's anything new or if they're being harassed or anything like that. It's just if they do it, you take it seriously.
That's correct.
On their own initiative.
That's correct.
Okay. What about CBSA?
We're not under the commission yet, so we don't have that check-in every 30 days since we're not part of legislation, and our current service standards are 40 days, so we don't usually need a monthly check-in because the complaint is resolved generally within a month and a week.
Okay. All right. Thank you.
Any further discussion? All in favor of NDP 28? All opposed? Defeated. That brings us to shall clause 44. Do we amend this? We didn't amend this.
As amended, yeah.
Okay, shall clause 44 as amended carry? All in favor? All in favor. Okay, carried. So we are set to stay here till 2. It's been suggested to me that we might need a bio break. So if it's okay, I think we'll suspend for 5 minutes or so. Oh, I said 5, but it's
5 is fine, sir.
Daylight saving times isn't quite yet. Anyway, 5 minutes. We are suspended. Resumed.
Resumed, yeah, I got it. Mr. Chair, just before we get into it, because I just don't want to interrupt during and at the end if we're rushing over to question period, we're making good progress, but the rate at which we're going and with all of the other committee work we still have to do before the holiday break is I'm going to ask and humbly request, even though this is never my first suggestion, that the clerk look into additional resources to continue clause by clause of C20, in particular for this Wednesday. And if we can't conclude by today and then with Wednesday's meeting, that we additionally look at additional resources. So again, I just didn't want to interrupt while we're in the middle of a clause, but I really think, given the timelines and how much we still have left to do, that we need to request some additional resources and then allow committee members to rearrange their schedules if need be or find subs.
Thank you. Mr. Julian, go ahead.
Sur ce point-là, Monsieur le Président,
On this point, Chair, I fully agree with my colleague. I had mentioned earlier, I think several times, that everyone is working in a very collaborative fashion, and this is good fun. It is a complex piece of legislation, so we do need to take all the time needed to work through each section. There are some important issues being discussed. Everyone wishes to work in a very positive way to get through this, but to ensure that we don't make mistakes as we go about improving this legislation, I do agree that we need to add extra hours. We may need this week, next week as well, some extra hours to get through the bill in the way that we are, which we shall do, but with more working hours, we'll be able to carry this through in a positive fashion. Without, though, putting off the following studies. We do need to go forward with our other work, of course, but only after getting through this bill. The best way to do this, I think, would be to sit Wednesday until midnight. That would be quite appropriate. We could get through all the amendments and carry out this hard work efficiently, but to get through it all.
Past my bedtime. Thank you, Chair. Just want to chime in on this a little bit. That recently, my staff and I did a little bit of a analysis of where we are and how quick we were going. I'm very confident that we can get through this by the end of next week with no problem. We're moving very quickly. We're still withdrawing a lot of amendments. I know my friend from the NDP mentioned he's withdrawing some amendments. I don't think that's rushing it too quick. The Conservatives are more than happy to work as much as we have to work. Our only concern is that it has to work for everybody. Chair, just last week, you sent out an email Friday morning, and I responded within 20 minutes and said that extra hour today is not going to work for some of our members of our team because it was just too quick and we all had other things on. And then within 2 hours after that, we got notification that the meeting was being extended by an hour. So we're not exactly working as a collegial team on that issue. So if we're going to be putting in extra time, we need to agree to it so it fits everybody's time. You asked us our schedules, what it was going to be like. I was very forthright with you and told you that it doesn't work for us today, and we still got that extra hours. So again, I think we'll be able to get done this quite easily by the end of next week. We're moving along very quickly. We're still withdrawing many. And I know, as I said, our NDP friends are withdrawing some. I think if we could all commit to get done by the end of next Thursday, it might be amicable to everybody. But we'll see where it goes.
Thank you all. So I have already asked the clerk to see what's available for us on Wednesday. I think we're doing great guns, moving very fast. We might even be done with normal hours on Wednesday. I would be very encouraged to, I'd be very in favor of extending on Wednesday so that we potentially could get entirely done on Wednesday. And then we could start on Bernardo next week. But I'm taking it as a general consent of the of the committee that we look for extra time on Wednesday, and how much extra time remains to be seen, what's available, but we'll, and I understand your concern, and, but I have to kind of go with the will of the majority here, so we will look for extra time on Wednesday. Okay, thank you. All right, that having all been said, we can carry on with clause 45. We go to NDP 29. Mr. Julian.
In the spirit of collaboration and to move things along, I withdraw NDP 29.
That brings us to CPC 14. Mr. Shipley. if you
I will be withdrawing CPC 14.
Withdrawn. So shall clause 45 carry? It shall. All in favor? On division, okay.
That's your role, Chris.
Clause 46 brings us to CPC 15. Mr. Shipley, if you will.
We will not be moving that amendment.
Withdrawn. Shall clause 46 carry? Yes. All in favor? Yes? Okay, it carries. Clause 47, CPC 16. Note that if CP 16 is adopted, Block 10 cannot be moved due to a line conflict. CP 16.
No fear of that, because we will not be moving that. See how quick we want to get through this?
I am thoroughly impressed with the efficiency of this committee.
You threaten midnight sitting.
That brings us to Block 10. Madame Michaud, allez-y, s'il vous plaît, si vous voulez.
Over to you, Madame Michaud. Thank you, Chair. BQ 10 is again a matter of concurrence to ensure that copies of communications be shared with the legal representatives of any complainant if there are notices to be given in writing.
Seeing none, all in favor of Block 10? Opposed? Carried. So shall clause 47 as amended carry? All in favor? Opposed? Carried. Clause 46, sorry, clause 48 brings us to CPC 17.
I will not be moving that amendment.
Withdrawn, okay. Okay, and brings us now to Block 11. Allez-y, s'il vous plaît.
Go ahead. Thank you, Chair. Once again, this is a matter of concurrence to ensure that copies of communications, any notices and writings, be shared with legal representatives of complainants.
Any discussion? Seeing none, shall Block 11 carry? Yes? Carried. Shall clause 48 as amended carry? Yes. All in favor? Yes? Opposed? No? Carried. Brings us to clause 49 and CPC 18.
Oops. We will not be moving that amendment.
So that's withdrawn. And takes us to Block 12. Allez-y.
Go ahead. Thank you, Chair. Block 12 is once again a matter of concurrence to ensure that legal representatives have a right to consult any written notices.
Okay, any discussion? Seeing none, shall Block 12 carry? Opposed? Carried. And that brings us to CPC 19.
Once again, to move things along, we will not be moving that amendment.
Very well. So shall clause 49 as amended carry? All in favor? Opposed? Carried. So we have new clause 49.1 with NDP 30. Mr. Julian, if you please.
I will withdraw that amendment as well as the two following ones.
So NDP 30 withdrawn. Okay, shall clause 50 carry? On division? Okay. So we go to get to clause 51. So NDP 31, I understand you're withdrawing. So shall clause 51 carry? On division? Clause 52, bringing us to NDP 32, and I understand you're withdrawing this one as well. And that brings us to Green PV3. That's Green Party, right? Yep. Is Ms. May online? No. Okay. So this is deemed moved. Is there any discussion? No. Shall PV3 carry? No. That brings us to block 12.1. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, the floor is yours. Thank you, Chair. So block 12.1 is an amendment to ensure concurrence, to ensure that non-governmental organizations, here we would change that to third parties, appointed to act in a similar capacity, representing an individual. I don't think this requires any further explanation.
Okay, so block 12.1 is moved with the change to a third party. Are we okay with that? Yep. Okay. Any discussion? Seeing none, shall block 12.1 carry? On division. Okay. That brings us to block 12.2. Allez-y, s'il vous plaît.
Over to you, please. Thank you, Chair. Once again, a matter of concurrence to ensure that non-governmental organizations, and right away, let's scrap that and say third parties, allowing them to file a complaint on their own without necessarily representing an individual or being directly concerned by the subject matter of the complaint. So this is to ensure that there's no discrepancy with another amendment that we've already carried.
Well, thank you. Is there any discussion? Ms. O'Connell.
Sorry, just to clarify, are we changing that to third party as well? Okay, perfect. Thank you.
Any further discussion? Seeing none, shall block 12.2 carry? On favor, on division? That brings us to NDP 33. Mr. Julian.
Thanks, Mr. Chair. In this case, this is a recommendation that comes from the Customs and Immigration Union. You'll recall in Clause 52, there's specific reference that the Commission must refuse to deal with a complaint if it relates to a disciplinary measure taken or not taken by the President. And the reality is, concerns have been raised by the Union about what that means is the Commission is not able to address issues that relate to abuse of authority when disciplined by management, or more importantly, I think, Mr. Chair, in the case of management deciding not to discipline a manager who is engaged in problematic behavior such as harassment. What the Customs Immigration Union recommended to us was that particular clause be taken out so that there is an access through the process for these types of problematic either disciplinary measures or measures where the commission, where where the president simply hasn't taken action within CBSA for managers where action should have been taken, particularly when it relates to harassment.
Thank you. I should mention that if NDP 33 is adopted or defeated, Block 12.3 cannot be moved due to a line of conflict. We have Mr. Motz, then Madame Michaud.
Thank you, Chair. This, if I remember correctly, is kind of in line with one of the other clauses that we went through earlier this morning, where we talked about it's outside of the purview of the Commission, and that they have to, this says they have to refuse it if a complaint relates to a disciplinary measure taken or not taken. And I think that's in line with comments that the department officials made earlier this morning in regards to, not weighing in on things that are of a department nature. And so I think I certainly support the idea of removing this from this particular piece of legislation that doesn't seem to fit with the explanation that was given to us earlier this morning. Now, I certainly would defer to Mr. Coops or others who might provide some clarity around subsection 3 here as it relates that I think should be removed. But I certainly defer to why it's there and whether that's a contradiction to what we talked about this morning about weighing in on something that you don't have any jurisdiction because it might cover off with another act.
We would offer at least two concerns about the amendment as presented. The first is that it would create an inconsistent condition between the Commission's authorities related to the RCMP as found in Sub 2, and then if Sub 3 were amended, the new condition created in relation to CBSA. So the Commission would be obliged to refuse a complaint concerning Part 4 of the Royal Canadian Mounted Police Act, which is conduct and discipline, but then would not be obliged to refuse the same under CBSA. To the substance of the amendment, removing that limitation on the Commission would be very much at odds with the design intent and the policy intent of the regime, which is that the Commission not be brought into matters of discipline, that matters of discipline not be brought before it, and that the means by which that is achieved is imposing on the Commission a duty to refuse to deal with a disciplinary measure because they are provided for, as we said earlier, by other processes under other statutes. The Commission would in any event not be able to adjudicate or review a disciplinary decision. So there would be no logical reason for it in any event to bring that decision before it for review.
Okay. Thank you.
Madame Michaud, allez-y, s'il vous plaît.
Go ahead, Ms. Michaud. Thank you, Chair. I simply want to state that I support Mr. Julian's amendment, given that I was about to present the same amendment, and this is indeed a request put by one of the unions, and I fully support it.
Any further discussion? Ms. O'Connell?
Thank you, Chair. Thank you to the officials for clarifying. I do see some concerns that we wouldn't want to see the PCRC just become another adjudication process for disciplinary action that someone is not happy with, that there are other means to do so, and that the PCRC is meant to deal with complaints outside of that, of disciplinary nature. And I think that it does kind of change the spirit of the act in terms of allowing for these sorts of complaints when there are already avenues to deal with them. So they may be very legitimate disciplinary complaints that should be questioned. I just don't think the role of the PCRC should be getting into that. So I can't support this amendment.
Very well. Any further discussion? Seeing none, shall NDP 33 All in favor of NDP 33? All opposed? Carried. Okay, block 12.3 cannot be moved. That brings us to CPC 20. Mr. Shipley, go ahead.
Thank you, Chair. Just before I jump in on this, as I regretfully, I'm going to have to be leaving. As I mentioned, I did have a previous engagement at 1 o'clock, so we will continue on with some substitutes, which is quite allowed. But as I said, the time wasn't permissive today to stay. We talked about that on Friday and then had another discussion on the phone about it. So I will move CPC 20 just before I go, though. And that explanation is that this amendment would ensure that the Commission cannot refuse complaints made about disciplinary measures or by serving members.
Very well. Any discussion? Seeing none. All in favor of CPC? I'm sorry, Mr. Julian?
Yes, I wanted to just ask the witnesses what they see is the impact of CPC 20.
Our assessment, if we've correctly understood, is that CPC 20 would erode the protection around the Commission's responsibility to deal uniquely with complaints and review of complaints, and that it may risk opening the door for the Commission to deal with things that are better dealt with under other existing statutes.
Any further discussion? All in favor of CPC 20? Opposed? Defeated? That brings us to new NDP 34. So if new NDP 34 is adopted or defeated, PV 4 cannot proceed since they're identical. Also, if NDP 34 is adopted, Block 13 cannot be moved due to a line conflict. So, Mr. Julian, go ahead with NDP 34.
Thanks very much, Mr. Chair. This is a recommendation folks around the table will recall from the Canadian Association for Refugee Lawyers. Currently, the bill, as proposed, says that a commission must refuse to deal with a complaint if the complaint has been or could have been adequately dealt with or could more appropriately be dealt with according to a procedure provided for under for any act of Parliament other than this act or any act of the legislature of a province. It's a significant loophole. One might say it's a loophole you can drive a truck through. And so what the Canadian Association of Refugee Lawyers had indicated is that we need to be more specific in the legislation about what are the circumstances in which the Commission may decline to hear a complaint. And so what is proposed here is in replacing that open language with that the Commission may refuse to deal with the complaint if dealing with the complaint would seriously compromise an ongoing investigation. The difference, of course, being that in the first case, in the current bill as drafted, there are any expectation that the complaint could have been dealt with somewhere else could lead to will lead to the Commission refusing to deal with that. In this case, with what the amendment proposes, the Commission has the option to refuse if there is an ongoing investigation. It tightens up the language and would ensure that it is only used sparingly in the case where an investigation through another entity has already begun. And so that was the recommendation for the Canadian Association of Refugee Lawyers, and I propose it as an amendment, a new Clause 5 in Clause 52.
Okay, thank you. So we have Mr. Jennings.
Thank you, Chair. Just before I begin on the substance of this, as a matter of process, my understanding was that this committee normally sits from 11 to 1, and that some of our members were consulted and they're not available to meet after 1, and that the meeting was scheduled anyways. So on that basis, my suggestion would be it would be most productive for all if the committee adjourned and scheduled at a time when the regular members from our side of this committee are available and when there's proper consultation about additional meetings. So on that basis, I would move that we adjourn.
The motion is to adjourn. All in favor of the motion? All opposed? We're going to record a vote. Go ahead.
1 second. I'm going to need 1 minute.
You had already called the vote, members had voted, and then a recorded vote was asked for while we were already in the process of voting. Like, let's just move forward here.
Permitted to proceed.
We will we'll do the recorded division here. All in favor of an adjournment? Yep.
Ms. O'Connell.
No.
Mr. MacDonald.
No.
Mr. Gahir.
Against.
Against.
Mr. Gahir.
No.
Mr. Biddle. No. Mr. Shifke.
No.
Mr. Jinus.
Yes.
Mr. Kurek.
Yes.
Monsieur Milelo. Yes. Mr. Lake. Yes. Madame Michaud.
Contre.
Mr. Julian.
Let's keep working. No.
7's in favor.
Thank you. So any further discussion on NDP 34? Yes. Mr. Jennis.
Thank you, Chair. Could I just, I think I made my point about the value of having regular members in the meeting be scheduled at a time when they're available, but given that that's not the appetite in terms of direction, I wonder if I could get the officials to explain for us what the substantial effect on the legislation would be of NDP 34 as it's proposed.
It would give the commission, the PCRC, more discretion to ensure that certain complaints don't fall through the cracks by making it discretionary.
It would give the commissioner more discretion to ensure
The commission, the PCRC.
Okay. In your judgment, is it likely that complaints would fall through the cracks otherwise, or?
It is conceivable that where we must refuse, that there are some circumstances where, yeah, it could happen, I would think.
Okay, what are the circumstances in which a complaint could fall through the cracks?
If we refuse based on, if we're required to refuse to deal with a complaint based on this, it's possible, there could be aspects, for example, there could be human rights related complaints that we take now, certain aspects of them, although in other instances it might be more appropriate for it to go to the Canadian Human Rights Commission. So it's discretionary.
It's discretionary for who? For the commissioner?
For the PCRC, for the commission, for the
Okay.
chairperson.
Okay, so this would oblige what exactly then to prevent it from falling through the cracks?
The amendment?
The amendment, exactly.
Well, it provides the discretion for the commission, for the chairperson to actually examine it and decide whether or not to refuse it, whether it's better investigated somewhere else or with the PCRC.
So the process that's envisioned by this amendment is one where it goes to the chairperson. The chairperson then has the discretion to examine, to determine whether they're going to examine it or someone else should examine it. And then, and how does that differ from the existing process? Or the process proposed in the absence of the amendment?
Well, the commission must refuse. It's not discretionary as written, as opposed to may refuse as amended.
The commission must refuse in a situation in which the complaint goes to the commissioner. The commission may, absent the amendment, the commissioner must refuse. Under what circumstances?
as written, must refuse to deal with a complaint if the complainant has been or could have been adequately dealt with or could more appropriately be dealt with. To go on.
Right, okay. So the effect of this is to give the commission the discretion to look at an instance in which the situation could be dealt with by another body, whereas the amended language just gives the discretion to look at it if the commissioner considers it.
Point d'ordre, Monsieur le
Yes, sir.
Président.
Call to order. Point of order. I believe that the explanation being provided by the official is very clear. I'm not sure why we're looking for further clarifications. I think that perhaps others would like to speak to this issue and explain their position, the positions of their parties, myself included. I'm not sure if Mr. Genius has understood correctly the very last explanations being provided by the official. If so, perhaps we could move on.
Mr. Jennings, go ahead.
Thank you, Chair. I'm happy to cede the floor and come back on this if others want to speak on it. So I'll cede the floor, and if you can add me to the end of the list so that I can hear what others have to say on it.
Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, the floor is yours. Thank you, Chair. I do have an amendment that appears directly after the one we're discussing, which is very similar. The aim is indeed to provide the Commission with a discretionary choice, saying it may refuse to deal with a complaint rather than it must. We say that it may refuse here. I think the NDP's proposal goes a little further than what we're suggesting. If we consider what the bill is trying to do, I think that this is beneficial, though. I wouldn't go on adding if dealing with a complaint would seriously compromise an ongoing investigation. I think that that intention is already in the wording of the bill. So I simply suggest that we don't adopt NDP 34, but choose instead BQ 13. And may I take advantage of having the floor to say it's worrisome to see, and let me be clear, there has been some filibustering from our good colleagues here. That made some sense on the Bernardo matter, but now, for a reason which is difficult for me to grasp, I don't quite understand, they seem to be pushing off the examination of what we're proposing here. I think this is very concerning. It's a very sorry matter. I have other things to propose as well in the hour to come. C20 is an important bill. It makes sense that we look for extra time to get through the work on it, given that there's been so much filibustering from the Conservatives on this matter. I think this is very unfortunate, and I suggest that we vote on NDP 34.
Point of order, Chair.
Mr. Jennings, on a point of order.
Just substantively, I have, and maybe my notes are out of date here, but I have the NDP amendment that says delete lines 1 to 3 on page 35. The block amendment that I have says exactly the same thing. 12.3 is the.
So we go now to Mr. Keurig.
Thanks very much, Chair, and it is good to be back at the Public Safety Committee. I know in the second session of the 43rd Parliament, I had the honour of sitting on this committee, and I think, other than Ms. Michaud, I think that it's all new faces here. So it's certainly good to be back, and certainly C20 is an interesting bill. And just to note, like Mr. Genuis did, I believe at the conclusion of the previous meeting, it was sought whether or not there was consent to extend this meeting, and it was not granted, yet here we are anyways. And it's unfortunate because for those of us that certainly care a lot about this issue and this bill, we have to dig into some of these things, I think is very important. So specifically related to NDP 34, the idea around giving discretion, I think, is something that it seems to me, certainly from what Ms. Michaud had said, and in light of, I believe, the next 4 amendments as well, that there seems to be a great deal of agreement on that. So I always find it one of the challenges when amending legislation is that when there are similar amendments that are brought forward that deal with substantively the same concern, to deal with one simply because it was submitted first versus taking the time to ensure that we are in fact passing the best legislation and the best what in this case would be changes to ensure that the Commission is given the necessary discretion to ensure as our officials, which I would just thank the officials for coming here as well. I know that it's important work that we do before these committees, so thank them. Now, Ms. Gibb, you had mentioned that the changing it from a must to may would give that necessary discretion. I would, however, just like to, if I could, ask for your opinion. I know that there is in BQ 13, it says the language is a little bit different here, and the reason I ask is just to make sure that we are doing justice each amendment as, although we can only deal with them sequentially, it allows us to deal with them to make sure we get the right thing passed. So BQ 13, which would be dealt with next, has slightly different language.
Actually, BQ, if this is adopted, BQ 13 cannot be moved.
Okay.
Sorry, just a point of order, Chair. I'm sorry. When I made my earlier point, I was referring to the wrong pages, but I am still failing to see what the textual difference is. I mean, they're written differently because BQ 13 amends a line.
Mr. O'Connell, on a point of order.
A point of order, it's going back to debate.
Very well. Thank you, and your point is well made.
The point is just I am trying to understand what the difference is between the 2 amendments, and I don't know if that's
difference between which 2 amendments?
You had just ruled that if NDP 34 is adopted, BQ 13 could not be moved. Are they substantially the same amendment, incidentally, or are they different?
As was stated to the committee at the outset of moving this motion, if new NDP 34 is adopted and defeated, PV 4 cannot be proceeded with since they are identical. Also, if NDP 34 is adopted, BQ 13 cannot be moved due to a line conflict. And that's just how things work. Carry on, Mr. McCurrick.
Thanks very much, Chair, and you succinctly.
Mr. Julian, on point of order.
Because there are a number of us who wanted to speak, could you please tell us what the speaking order is?
Absolutely. This on my list is Mr. Julian, Mr. Jennis, and Ms. O'Connell at this time, following Mr. Currick.
Yeah, through you, Mr. Chair, to our new colleagues around the table. Our practice here at committee is to speak briefly and then allow others to speak as well. And so I would hope the new members of the committee who are substituting in would respect that.
Thank you for your input. Thank you. Mr. Currick, go ahead.
Thank you, and to Mr. Julian, I had the honor of serving on this committee, as I stated in my opening comments, from the second session of the 43rd Parliament, and certainly I would hope that he nor anyone would want anything but the best legislation to result from our discussions here. And in light of that, my point to chair what you had quite succinctly articulated. The reason why, Ms. Gibbs specifically, I'd like to ask the question in comparison between the substantive similarities between NDP 34 and BQ 13. One is slightly longer than the other, a little bit different language. So if we end up passing 34, 13 is not able to be moved. However, the reverse of that is also true, that if we do not pass 34 but can pass 13, that would, if that in fact is the better option. So Ms. Gibb, or to other officials that would be able to weigh in, could you outline specifically if this was to pass versus some of the other wording, could you outline what some of the differences might be and how the interpretation of that in the Commission's work?
It seems to me that both amendments have a discretionary clause to them to change the first part of sub 5. But the NDP one references seriously compromised and ongoing investigation as opposed to stating another act of Parliament. I'm not the lawyer here, so I can't interpret the difference, but seriously compromised and ongoing investigation suggests to me that we're referring to CBSA's investigation or an RCMP investigation as opposed to sending it, say, to the Canadian Human Rights Commission.
Okay, thank you. So the intent here is to ensure that the Commission has the necessary discretion. So does the language in 34, does it end, and feel free to invite your colleagues in as well, but does it take away some of the discretion that is, I think, being suggested through the amendment by adding the seriously compromised and ongoing investigation, whereas the other amendment simply says may? Is there a substantive difference in terms of how that would be interpreted and the impact that that would have when this discretion is utilized?
I think the NDP 34 limits discretion because it only provides for limiting it to if there's if there's another investigation in place, whereas the other provision continues with the other factors as far as the complaint could be more appropriately dealt with by another act of Parliament.
So if I could follow up on that, so it's adding discretion, but narrowing the scope to which that discretion can be applied. Could you provide some context as to what the practical effects might, what the practical effects of that might be in the ongoing work, and when that, because discretion to be added but to be limited in the right context, that makes perfect sense, but to ensure that we find that right balance, so I'm wondering if you could provide some
I think
further
it
context.
could potentially require the PCRC to look into other things that could be more appropriately dealt with by other acts of Parliament, because they're limiting it to just whether there's an investigation.
So if I could again follow up on that, so other acts, for example, the Human Rights Commission and other types of investigations. So do with this narrowing of that discretion, would that prohibit complainants from having access to the full scope of what is intended through that this legislation is meant to bring forward?
No, but I think it might require the PCRC to look into other things that could be more appropriately dealt with by other acts of Parliament. For example, a complaint with respect to official languages that could be more appropriately dealt with through that specific act.
Okay, and whereas when as we see in BQ 13, the simplicity, as a general rule, simple is better, and that's sometimes a tough thing in government to say, but the simplicity of the amendment of BQ 13 fails to allow for that appropriate discretion to be provided in the context for which
Could we stick to
investigation.
NDP 34, please?
Happy to, Chair, but certainly for whether or not to support NDP 34, I think these are important questions that need to be asked as the passage or not passage of NDP 34 affects whether or not we debate BQ 13. Yeah. So and your title, I had a list, but your
With
your
your
title.
CP.
Yes, is it constable?
It's assistant commissioner.
My apologies. So just to make sure that we have that appropriate scope, when looking at the difference between the bill having seriously compromised an ongoing investigation, is that, in your opinion, would that be an appropriate limitation on the added discretion that would be imposed by the passage of NDP 34?
I think it provides discretion, but because it replaces everything else that was previously in subsection 5, it could potentially require the PCRC to, or not provide the PCRC with the ability to turn things down if they could be more appropriately dealt with by another act of Parliament.
Okay. Thank you.
Go to Mr. Julian, please.
Thank you very much, Mr. Chair. I mean, I think it's quite clear. If we want narrow scope in terms of the Commission refusing, we should adopt NDP 34. If we want a slightly larger scope, as Madame Michaud indicated, we can look to adopt BQ 13, but we actually need to get to a vote. I am a little perplexed by the filibuster around NDP 34, Mr. Chair, because we had a one-month filibuster, you'll recall, where finally the NDP motion was essentially adopted around the Bernardo transfer and the transfer of offenders. Now we are filibustering, or one party around this table is filibustering Bill C-20. Now they're filibustering NDP 34. And in doing so, they're actually stalling the study that they filibustered for a month on. It doesn't make sense. It's sort of they're filibustering themselves. So Conservatives are now filibustering what they finally agreed to, the NDP motion, a few weeks ago. Now they're filibustering the bill and filibustering the study that they said was important to get. So I'm very perplexed about the filibuster around NDP 34. Doesn't make sense at all. And I've said this many times, Mr. Chair, there's two bloc parties in the House of Commons. There's the Bloc Québécois and there's the Bloc Everything. And the Conservative Party seems to be blocking everything, including Bill C-20, NDP 34, and good legislation that will make a difference in putting in place a Public Complaints Commission that will actually is something that so many people in this country are calling for. So the delay around this, the filibuster around it, and filibustering the study around transfer of offenders within the correctional services makes no sense at all from any standpoint. And I'm just very perplexed about the member from Carleton and his approach to the House of Commons, trying to block everything at all times.
Thank you, Mr. Julian. Go back to Mr. Jennis, followed by Ms. O'Connell. Mr. Jennis?
Thank you, Chair. I had some questions, but since it's on the table, maybe I'll just respond to some of the comments made from Mr. Julian. Of course, we have two parties currently in the opposition and two parties currently in the government, and
point of order,
they'll certainly
Mr. Chair.
Be accountable for that.
That is factually completely false, and Mr. Jennis knows that. There are three opposition parties. There's one government party.
Yeah.
Point taken, well made. Thank you.
Chair, I've always esteemed your neutrality in these proceedings, and to Mr. Julian's point, I do not think it's factually inaccurate at all, and whether or not it is not a matter of order. The NDP have made a choice when it comes to providing a relative blank check on confidence to the government, and they can't very well take advantage of that and train all of their fire at their their so-called fellow opposition parties.
Point of order, Mr. Chair.
I suspect it's not a point of order, but go ahead.
It certainly
Mr.
is.
Mr. Julian on point of order.
Yeah, as you know, Mr. Chair, you enforce rules around relevance and repetition, and there is no relevance right now to what Mr. Jennis is actually saying. We're discussing NDP 34 as part of Bill C-20. I would ask you to enforce that rule of relevance with Mr. Jennis.
Mr. Lake on the same point of order.
Point, just if we're being consistent, the honourable member just had a slot to debate the NDP amendment that he's talking about. He's in the NDP, and he didn't use one word of his time slot to talk about the amendment, to actually talk about the amendment. So if we're on the issue of relevance,
Thank you. Thank you. So, given that Mr. Julian had spoken in regard to other matters, I was giving Mr. Jennis a little bit of leeway. However, I would certainly appreciate if Mr. Jennis would get back to the matter of hand, which is NDP 34.
Thank you, Mr. Chair. I will return to that after I have ever so briefly dispensed with the arguments of Mr. Julian. He had cast some aspersions around the work Conservatives had done previously at this committee, insisting on 3 meetings to hear from minister as well as family members involved in the issue of the Bernardo transfer.
Mr. Jennis, come to order, please. We're not discussing the debate around the Bernardo study. The matter has been discussed.
I'm just responding to Mr. Julian.
And please get back to the matter at hand, which is NDP 34. You had an opportunity to respond to Mr. Julian already. Let us carry on with the NDP 34.
Mr. Chair, on a point of order, there are not time limits associated with this part of the proceedings, and if a chair, in violation of the rules, imposes time limits, then the new standing orders provide for a member to be able to raise a point of order, bring that matter to the attention of the chair
Mr.
in the
Dennis?
House, and all subsequent proceedings are disallowed. You should be aware of the rules.
Mr. Jennis, come to order.
Point of order, Mr. Chair.
In your time, I have not established a time limit. I'm just asking you to get to the matter at hand. It is appropriate to stick to the matter at hand. If we can try to not bring in extraneous matters, we can get forward on this. Mr. Julian on point of order.
I actually agree with you, Mr. Chair. The issue of relevance and repetition are the 2 key elements here. And Mr. Jennis is not being relevant to NDP 34 and Bill C-20.
On the same point of order, Chair, it is really unfathomable to me how Mr. Julian could make...
I didn't recognize you on a point of order.
I profusely apologize. Mr. Chair, I have a point of order that I'd like to raise.
Mr. Jennis on the same point of
order. Thank you for graciously recognizing me. Mr. Chair, Mr. Julian was able to make an extended intervention that was not on the topic of his amendment. I am trying to provide a perfunctory response to Mr. Julian.
Mr.
And
Jennis?
Mr. Julian is now raising points of order to say, I am not being relevant for responding to him.
Jennis,
and now you are interrupting
Mr.
me
Jennis,
again.
Come to order. You had a chance to respond to Mr. Julian. Let us get back to 34, if you will.
In a narrowly prescribed time limit that is nowhere in the rules, Chair?
Once again, I have not prescribed time limits. Go ahead but
Mr.
you need
Chair,
to stay on topic, which is NDP 34.
Mr. Chair, I am responding to this discussion, but I will say with respect to NDP 34, an accusation was leveled by Mr. Julian that there is some kind of a filibuster going on NDP 34. And I think on the subject of NDP 34, it's important to respond to that allegation about the questions that we are asking. The process as it happened was that Conservative members who are regular members of this committee, I am not a regular member of this committee, were asked about their availability in a particular time slot outside of the normal time slot.
Point of order.
Mr. Jennis. Mr. Jennis, you're out of order. The matter of scheduling of this meeting is
not out of order, Chair.
Matter for discussion today. That was a matter discussed by the majority of the committee offline, but it was a decision of the majority of the committee. It was a majority decision. That matter has been addressed. We have scheduled this time. It's not a subject of discussion at this time. Please return to the matter of NDP 34. Mr. Lake on a point of order.
Yeah, also subbing in on the committee, you just said that the decision was made in an offline meeting of some members of the committee. Were all members of the committee part of that offline?
It was not an
unofficial
offline meeting. The
You just
decision was-
you just said there was an offline meeting.
No, I didn't.
An offline discussion.
Point of order.
Ms. O'Connell on a point of order.
Thanks, Mr. Chair. First of all, the lack of disrespect being shown to you in this matter of when you're speaking and interrupting you and saying, yes, it is, no, it's not, is frankly embarrassing for who are supposed to be experienced members. And I would suggest that you stop embarrassing yourself on the point of order in terms of the questions about why we are here right now and what is occurring. I find it incredibly interesting that 1 hour of extra work on a study has caused such fragile egos to be so upset that the good old boys have to come here and disrupt important legislation. And Mr. Chair, I hope that they'll get back to continue
Thank
to
you.
interrupt while I have the floor. Just proves my point about the behavior and lack of respect that
Point
is
of order.
a point of order. So, Mr. Chair, I would ask that decorum of these meetings be upheld. And if members opposite cannot
Point of order.
control their emotions, then the chair rules them out of order and cuts off their mic.
Excuse me. Thank you. I believe this was on topic because we are having a problem with decorum here and having a productive meeting. So while Ms. O'Connell was speaking, there were a couple of points of order. I lost track. I think Mr. Lake, you were first.
So just given that you allowed Ms. O'Connell's point of order, so on that topic, we're sitting here today. From our understanding, a meeting was called business day ago. Our members clearly couldn't make that meeting because they had other obligations. So we've got 4 members here sitting here who are not familiar with the legislation, trying to do the best we can to understand by asking questions.
As said, that has been dealt with.
But we're continuing to deal with it, and Ms. O'Connell was...
It's the chair's prerogative to schedule meetings and to set the agenda.
Right.
I did so on consultation with all of the parties around the table. It was agreed, except by Mr. Shipley, that we should proceed with an extra hour today. That was well in keeping with my prerogatives as chair to do so, and I did consult with all parties, and a majority basically determined that it was okay to do this. But that matter is done. We can't unschedule this meeting. So if you want to carry on wasting time, I mean, I can't stop you, but...
Point of order, Mr. Chair.
Don't interrupt the chair, right? So you may continue with your point of order if you wish, but I just want to advise that this matter, the matter of having scheduled this meeting or not, is done. It's a fait accompli.
The point of order is, Mr. Chair, respectfully, you just accused us of wasting time with what we're doing here. I was on House duty today. We needed a slot filled today. I volunteered to come over and fill the slot. I don't know the legislation that's being discussed today. And because a meeting was scheduled where no member of the sitting member of this committee on the Conservative side could be here, the legislation would just flow through without any of the issues that our experts on this committee might want to raise, right? And so we're not wasting time. We're trying to step in because a decision was made without our agreement to hold this meeting, and we're here filling in, doing the best we can to ask questions to understand what's happening with the legislation. It's not a waste of time. It's us doing our job.
We do not need unanimous agreement to do these things.
Fine.
If you wish to ask questions about NDP 34, by all means do so, right?
Perfect.
If you want to talk about all kinds of extraneous issues, I'm asking you that you don't do that.
Okay.
Stick to NDP 34, please.
Okay.
Had the floor.
I had a point of order before I resume my comments, Chair, and that is just that I would encourage the Chair to be fair and to act in a way that at least aspires towards some degree of impartiality, because when Ms.
Point of
O'Connell
order.
is permitted to speak at great length on a
Julian,
matter that's
on a point of order.
sorry,
Yeah.
I am on a point of order already, so it's not automatic that you end my point of order in the middle.
I did not recognize you on a point of order. Mr. Julian, go ahead.
Thank
Okay, I'd
you,
like to be
Mr.
recognized on a
Chair.
point of order
It's
subsequently.
highly inappropriate what Mr. Genis is doing. He's not being relevant, and he's attacking the chair, and that's, I think, it does a profound disservice to parliamentary democracy. So you certainly have, I think, the support of the vast majority of members of the committee to bring him to order.
Thank you, Mr. Julian. Carry on. You have the floor, Mr. Genis.
May I raise a point of order, Chair?
Mr. Genis, on a point of order.
Yes, thank you, Chair. Ms. O'Connell was permitted to speak at great length on matters that were clearly not matters of order. You've allowed other members to address things that are unrelated to the amendment on the table. But then when I and other Conservative members seek to respond simply in line with matters that were just raised, you immediately cut that off or call that a lack of decorum or something. And I've dealt with a lot of chairs that have been that are elected Liberal members of Parliament, and I have encouraged them, as I'll encourage you, to aspire to impartiality in the context of their role in the committee and to seek to enforce the rules. That's my point of order, and I'm happy to return now to my substantive remarks. And that was simply to say I do have some specific questions that I want to bring to our witnesses with respect to the amendment. I do want to say that Conservative insistence on having 3 meetings to address the issue of the Bernardo transfer was very reasonable and very well supported,
Mr.
and I'm
Genis?
glad we
Mr.
achieved that
Genis?
result. With respect to C-34,
Genis?
yes.
Come to order. The Bernardo meetings, the number of meetings we had to discuss it, how many meetings, not on the table right now. We're discussing NDP 34. Please stick to that.
Yeah, Chair, as I said, I was seeking to respond in a perfunctory way to comments that were made by Mr. Julian, and I think that was reasonable.
Mr. Julian, sorry,
my
Mr. Genis, you had a chance to respond to those remarks by Mr. Julian. Please carry on with NDP 34.
Mr. Chair, I don't understand the basis on which you're saying I did have that chance when I did not and was constantly interrupted.
Point of order, Mr. Chair.
But I'm.
Mr. Schiffke on a point of order.
Thank you, Mr. Chair. It doesn't look like we're going to be getting back to the business of the bill that we are supposed to be addressing today. And we have 22 minutes left, or roughly 20 minutes left, before we all have to depart for question period. I would simply ask that the guests that we have appearing before us, the witnesses, are let go and asked to leave, because 20 minutes spent here is 20 minutes that they are not serving Canadians, and therefore I would simply ask that they be let go so they can pursue all of their important work. Thank you, Mr. Chair.
Chair, just on the same point of order.
Excuse me. Thank you, Mr. Schiffke. Is it the will of the committee to invite the witnesses
Can I
to
raise a
withdraw?
point of order on that, Chair? Report.
We're going to decide this matter.
Okay, then no, there isn't agreement.
Is it the will of the committee to...
There's an important point here to make.
Yeah.
If we release the witnesses, there's no point in us having the meeting, so we might as well just adjourn the meeting. The meeting is to hear from the witnesses.
Yeah, so
What is the rest of the meeting if we release
I'm game
the
to adjourn
witnesses?
the meeting, but there's no point in dismissing the witnesses and not adjourning the meeting if we're continuing to discuss. Apparently
the
supposed to
point?
continue discussing the clause.
Well, it really
so.
depends on whether
Point
what you
d'ordre,
guys
Monsieur
want to
le Président.
discuss. Madame Michaud.
Point of order. Thank you, Chair. If the Conservatives would like to keep the officials here, perhaps they could make use of their presence by putting questions about the amendment.
Boils down to the will of the committee. Do we want to carry on and ask questions of the witnesses? Yes? So, Mr. Jennings, you have the floor on NDP 34.
Yes, thank you. Thank you, Chair. I keep being sort of about to pose questions to the witnesses, but trying to briefly deal with other matters first and then getting interrupted in my attempt to briefly deal with those other matters. So this legislation, Bill C-20, we have 4 regular members of this committee that I think made clear to the chair that they were not available for the additional time proposed outside of the time slot. Hence, we are here asking questions.
Leave it alone. We're done
Chair,
with that.
I don't understand your approach to chairing this meeting at all. But
stick to the topic at hand. That is
Sure.
the requirement.
It is the topic at hand.
The
I'm
topic at
talking
hand-
about the bill. You don't like what I'm saying, but it's still a topic at hand.
Is NDP 34. Do you want to ask questions of the witnesses or not?
Could I ask? I read it to my kids every night, Mr. Julian. So I respectfully, there is nothing I enjoy more than discussing the rules of the House of Commons. And I'd invite chairs to, and this particular chair, to avail himself of that opportunity. To the witnesses, I wonder if you could just clarify, in the context of NDP 34, it envisions other entities potentially looking at complaints that may emerge. And I wonder if you have a list or could suggest a list of all the various entities that might be conducting an investigation such that would lead to the Commission to deciding either that it must or that it may, depending on if this amendment is adopted, refuse to deal with the complaints. I heard mention of the Human Rights Commission, the official languages. I want to make sure I have a clear sense of what the various other bodies that could be conducting investigations would be.
We don't have a list. The amendment doesn't appear to include one. We would suggest that in that case it may be very open.
Okay, so what other types of bodies, presuming federal government bodies at least, would be your interpretation of this wording, or could this include other bodies that could conduct investigations that are not under? I mean, you could imagine a situation in which some international body was conducting investigations on similar matters, or provincial. If there was some ambiguity around, so what's like? Again, this is sort of the base of the question, is that it's very open. But what range of bodies or other types of bodies do you imagine that this would be referring to?
It could also refer to the serious incident bodies in the provinces that investigate potential criminality against police officers. We have a chair-initiated complaint currently that we're putting on hold because it is under investigation by a provincial body. But we wouldn't necessarily refuse the complaint, or we might hold it in abeyance, as opposed to the as written must refuse, as amended may refuse.
Okay. Do you think the may refuse provides you with the flexibility around holding it in abeyance, for example, or is there language that should need to clarify the option to, I guess, neither refuse nor investigate, but to park, let's say, for later?
Yeah, there are other provisions for suspension.
Okay. All right, and so the if the must changes to may, this provides you with the flexibility, you think, to would provide the body with the flexibility to make the suspension.
Not necessarily, the suspension, but to accept it or to not accept the complaint. Yes.
Right. So I just want to understand how those other aspects that you referred to in relation to suspension would potentially interact with the provision here. So if a complaint were brought forward that you thought might be being dealt with at another that the body thought might be being dealt with elsewhere, maybe pending further consideration. Do the other provisions provide the flexibility to have a suspension in the meantime, or is it unclear on that?
Sorry, we were just discussing some potential scenarios. But yeah, so the question I was asking my colleague was, say the Canadian Human Rights Commission, if they were investigating something, or we thought it was more appropriate for them to investigate. This amendment, the first part, the may, would allow us the discretion to decide whether it would be better placed with another act of Parliament. So the second part of the NDP amendment is somewhat different than the way it's written here. So with an ongoing investigation, for example, which it may be that suspension would be the better thing to do than to refuse, either be required to refuse or have the discretion to refuse.
Right. So I guess, I have some questions about that, but just specifically what I was asking is, if this passes, do you have the discretion to suspend without refusing to deal with or deciding to deal with? Do you have the flexibility to suspend consideration, let's say, pending the continuation of that other process?
The suspension provisions still exist, yes?
Right, and they would apply in this kind of scenario. Sorry, I want to come back to the issue of other bodies, but this just reminds me, what is your interpretation of sort of the difference between, because now that I've sort of zeroed in on it, the difference between not the must versus may, but the seriously compromise an ongoing investigation by any other person or entity versus could have been adequately dealt with or more appropriately dealt with according to a procedure provided for under another act of Parliament. I guess it seems to me that in one sense the NDP amendment does provide for less discretion insofar as the only case in which they may refuse to deal with it is if there is a concern about a serious compromise to another investigation. So there might be a case in which it's determined that it wouldn't seriously compromise another investigation, but it would still be more appropriately dealt with at another body. And the implication of the new language is that effectively the Commission doesn't have the flexibility to refuse in that case. They only have the flexibility to refuse if there's a basis for believing that there would be a serious compromise to an ongoing investigation. Is that is my understanding accurate, or am I missing something?
Yes, I would be concerned with this seriously compromised, what that means, but also ongoing investigation means, so another body's already taken carriage of it and is investigating it, as opposed to the way I read this clause now, is that the Commission would believe it could be dealt with better at another body. They may not be, the other body wouldn't be seized of it yet necessarily, the way it's written in the bill, but they would have to be seized of it and have an ongoing investigation with the amendment.
Right, that's very interesting actually to draw our attention to the word ongoing, because suppose you have a situation in which an issue has been brought to a Human Rights Commission, the Human Rights Commission has made a decision on it, and then another complaint is brought to the Commission because the decision was made by the Human Rights Commission, it would not be an ongoing investigation, it would be a complete investigation, and as such, the revised language would not give the Commission the power to refuse to deal with it. Is that correct?
Yes.
Okay. So it could be the case in advance of or after an investigation was done at the other body. I would be curious for Mr. Julian's response to that to this, because it does seem that while the intention, the way the presentation of this was framed as being around providing a greater degree of flexibility, it does seem to provide, in that particular sense, less flexibility. The reference is seriously compromised. Is that sort of descriptor defined somewhere in the legislation or in the criminal code, or is it sort of subject to to interpretation, what would constitute a serious compromise or a or a compromise that's not so serious?
No, it's not defined in the legislation, or in the bill, sorry.
Okay, and is it defined, would it be defined elsewhere in the criminal code? Would there be sort of a standing basis on which that would be interpreted, or is that kind of left to some how would, you know, based on your expertise, how would you understand that to be interpreted in practice?
Yes, it's left open for interpretation, so the commission, or, yeah, in this case it would be the commission, would determine, possibly based on case law, based on previous case law, as a determination based on the civil law.
Okay. So, if this also, the combination of may and a serious compromise imagines a situation in which the commissioner could view a situation, the proceeding of a complaint before the commission as seriously compromising an ongoing investigation elsewhere, and yet still have the flexibility to choose to deal with that complaint. So is that right, that the flexibility in the may implies that actually I think this is designed to ensure that a much greater volume of complaints must be considered, and in some cases can be considered. Is that I think I'm answering my own question, but is that correct? Or did I?
Well, I can't speak to the intent, but it may be the result, yes.
Okay.
Mr. Jennings?
On the issue of, yes?
Given that it's 8 minutes to the hour and members have to get to question period, I'm wondering if it's the will of the committee to adjourn at this time?
No.
No?
Mr. Chair, because
Very well. Carry
I
on,
have something
Mr.
I want to
Jennings.
say.
Okay, I'll cede the floor, but maybe add me to the list again so I can follow up, because I want to let Mr. Lake have a chance.
Ms. O'Connell.
Thank you, Mr. Chair. I find it just very disappointing what's taking place over an hour of extra work that the Conservatives had to put in. And as parliamentarians, we're all expected to stay up to date on legislation. And if there is an inability to do so, that when one comes to a committee, if you don't come prepared, that doesn't get to hold up the work of everybody else. And I think since there was referencing children, we wouldn't expect children to behave, to come to.
I'm sorry.
Okay.
Was Mr. Kirk, do you have a point of order?
Just wondering about relevance here, Mr. Chair.
Thank you. I would urge Ms. O'Connell to stay relevant to what we're doing here.
Perfect, I will, thanks. I'm talking about coming prepared to deal with these motions, since there was lots of questions about what page number, where we're on, and things like that. And so, like I said, we would even encourage children to come prepared to do their work. And if they don't, that it doesn't become everybody else's problem because they chose not to do their work. So when it comes to NDP 34 versus Block 13, we support the intention behind this. We just happen to prefer Block 13 better. But, we're working collaboratively. So on that note, Mr. Chair, I'm going to move a motion to adjourn.
There is a motion to adjourn on the floor. All in favor? Opposed? Carried. It's done.
Vote before you made the ruling.
I did not hear, sir.
This is